Yeah, right, sir.
Good evening to all of you.
Slowly.
We are just going to a new topic called Hindu Law of Adoptions and Maintenance Act 1956. First and foremost in every enactment is we must know the alphabets of the enactment. The alphabets, I mean the interpretation clause giving the various definitions. Section 3 of the Act defines what is called custom and usage. That is, custom means what has been continuously, uninterruptedly, without any obstructions, being continued for a long time in a particular community, particular tribe, or particular family or group is what is called a custom. Normally, to explain this properly, India is a country of unity and diversity. We have got different communities, we have got different subcastes, we have got different tribes, we have got the Adivasis also, and customs differ from community to community. Here, first and foremost is if you take the case of a Hindu takes in adoption of only his near relatives normally, or from an outside family also. There is no but. But as far as the Muslims are concerned, Muslims adoption is not permissible, and in Muslims it is only fosterage. That is, a male child is brought from another family and brought up as a own son. But as far as the child is concerned, child does not get any rights as far as inheritance is concerned. In the same manner, as far as Christians are concerned, there is no custom of taking children in adoption. Adoption is not permissible or not recognized as far as Christians are concerned. As far as the Hindus are concerned, and or a particular community or as far as Muslims are concerned, there is a custom as far as marriage is concerned. What they do is a girl of a particular brother gets married to her uncle's son. That is, a father's brother's son is married to her. That is a custom. Of course, as far as Hindus are concerned, it is supposed to be a consanguine marriage. It is not permissible. But as far as Muslims are concerned, it is followed from times immemorial. And in Muslims, there is a custom that they don't take the sister's daughter in adoption or take the sister's daughter in marriage. Why? Because that is not permitted. I do not know. That is a custom followed by Muslims from times immemorial. But as far as tribes are concerned, they have got their own usage, they have got their own customs, they have got their own way of living. Of course, it differs from community to community, group to group, and also what is called tribes also. And a custom means a ana avati antaru Telugulo. That means which has been continued, which has been followed from times immemorial without any interruption, without any breakup, or without any what is called interference from anyone. So that is what is called custom. Sometimes what happens is customs enjoy the unique status. They override the law in certain circumstances. And in that particular case, what happens is custom plays a very important part. Usage, you custom and usage almost goes together. Usage means a usage which has been followed from times immemorial, like place of worship, way of celebrating festivals, way of having festivities, a way of having functions, get together, so on and so forth. That usage is being continued uninterruptedly, continuously, without any break. It is called a usage. So custom and usage plays a very important part. And if a custom is established, sometimes customs overrides the law and the courts are bound to follow those customs. Then I'll put it another way also, sir. In Brahmins, you have got two communities called Vaishnavites and Saivites. Here, as far as Vaishnavites are concerned, they have different rituals. That is what is called the Samasarnam. That is what is called the Shankha Chakram is put on the two shoulders, and then the boy gets the right of what is called performing various religious functions. And then you got the Bharanyasam. Bharanyasam means that is where you only worship one god and you dedicate yourself to the cause of Lord Vishnu. you don't worship any other god. Then you got what is called, of course, in Vaishnavites, you don't have sannyasa, where you renounce the world and become a hermit. But as far as Saivites are concerned, they do not have this sahasas, this samasaranam, bharanyasam, so on and so forth. But here, one thing is this: Saivites worship Lord Shiva, and they dedicate themselves to the cause of Shiva, and they only recognize one god called Lord Shiva. And as far as the agoras are concerned, agoras or Naga sadhus are concerned, they worship Shiva and they dedicate their entire life to the cause of Shiva, and they do not worship any other god. So these are the various customs which are the various usages which are followed by different communities, different groups, and different tribes and different individuals. So as far as sannyasa is concerned, it is recognized only in the Saivites, but in Vaishnavites, you do not have sannyasa. Then sannyasa means renouncing the world. But here, these usages, these customs are being followed from times immemorial, and it has it has assumed or it has taken the shape of law, and it is normally recognized by courts and given the sanction and given the force of law. That is what is called custom and usage. The second one is maintenance. Maintenance is Jivanamsham, as you call it in Telugu. After all, every one of us, every living human being requires roti, kapra, or makan. That is what is called food, shelter, and clothing. And to keep the body and soul together, we eat. And for the purpose of eating, we try to work, we try to toil, we try to struggle in life and make a living by earning and trying to maintain yourself and trying to maintain your wife, trying to maintain your children and look to all their needs. That is what is called maintenance. Suppose, let us say, a lady who's married is deserted by her husband, or the husband is not providing her any money for her maintenance. Then, in that case, she can always ask for what is called Jivanamsham or what is called maintenance. Maintenance is also recognized in the Criminal Procedure Code, that is under section 125. That is, she can ask for maintenance, saying that she is unable to maintain herself and the husband is better off, and then he is bound to maintain the wife till the marriage subsists. And the question is, what is the quantum of maintenance? Quantum of maintenance, as in the original CRPC, that is section 125, provided that the maximum amount that can be awarded as maintenance is only 500 rupees. But 500 rupees was yesteryears. Of course, you know, when the old criminal procedure code was passed somewhere in the 19th century, the question is, with 500 rupees, you cannot purchase anything. You cannot purchase groceries, you cannot purchase clothing, you cannot have food also. So that time by time it has been extended. Now the Hindu law of adoption, and one of the cases I'll cite where I think most of you are watching YouTube also, where proceedings are taking place in various high courts. In that, even in the Hindu Marriage Act, you have got section 24 of the Hindu Marriage Act, which says interim maintenance and expenses can be claimed by a wife who is unable to maintain herself. There, in a particular case, what happened was a petition was filed under section 24(1) in the family court of Bangalore. And there, what happened was the interim maintenance which was awarded was only 1 lakh. Then the wife went up by way of a CMA before the High Court, and fortunately or unfortunately, the bench was presided over by one lady by name Justice Lalita. And the claim which was made by the wife was 6 crores, 6,15,300. Then the breakup which was given is, she said she wanted 4 lakhs because she's suffering from joint pains and orthopedic complaints, and she wants 4 lakhs for the purpose of her surgery or for the purpose of her physiotherapy, etc., etc. And she claimed 50,000 towards per month. I'm not talking about per year, per month, 50,000 towards her cosmetics, for shoes or for sandals and for other things. Then other things, I think she claimed a consolidated amount of 6,15,300. Then the judge immediately shot up and said, "How could you ask 6,15,300? And husband is earning, no doubt about it. But If you are also equally qualified, you are a PG graduate, you are a postgraduate. If you want that much money, why don't you earn? Why are you placing the burden on the husband? And he said, I've never heard of a lady asking for 50,000 rupees towards her cosmetics and towards her footwear and other things per month. And as far as the children are concerned, you are not bothered about it. You want the children to be taken care of by the husband and not by you. So they said, you give a fresh breakup and then come before the court. If not, I'm dismissing the application. Then the advocate was appearing, a lady advocate was appearing for the husband, argued, saying that, sir, this lady has got 65,000 shares in different companies. She gets dividends from various companies and she is able to maintain herself. Then the court said, both of you file particulars affidavit and what is the respective claims you have got. And your claim is usurious and you cannot make the husband a scapegoat and make him suffer and pay such huge amount towards your maintenance. So that was what was argued before the Karnataka High Court. So the question is, in another case, of course, it's not reported. In another case, the husband was earning 50 crores. The wife made a claim for maintenance, claiming 1 crore towards her maintenance per month. The court in that particular case said the husband may be earning 550 crores, but how can you claim 1 crore towards your maintenance? What about the children? Are you not going to take care of your children? If you are qualified, why don't you work and make money and use it in whatever form you want? And the court openly said you cannot make the husband a scapegoat and make him a pauper as far as maintenance is concerned. Please remember, maintenance is a weapon in the hands of the woman. To, of course, the women chauvinists may not agree with me to say that to make the husband a scapegoat. It happened in our own Telangana High Court in a particular family court appeal. The husband jumped from the second floor on the ground. He said, "I'm not able to able to uh, able to manage the court. The court is trying to make me a pauper. I'm completely frustrated. I'm going to commit suicide." So what happens is, no doubt, maintenance is definitely required. No one says that maintenance should not be awarded. But the question is, there must be some reason, there must be some reasonable amount, there must be some amount which the husband can spare in order to maintain his wife. Then the question next arises is, now a new act also has come. Maintenance of the BNSS also has provided, saying that when the aged parents are there, it's a responsibility of the children to maintain the aged parents. They cannot throw them out or admit them in the old age home and then try to get away. Please remember, you owe a social responsibility as far as the parents are concerned. That is, as far as the old age parents are concerned, it is a paramount duty of all the children to maintain the aged parents. In one of the classic cases, what happened was a 77-year-old, I don't say boy, a 77-year-old man filed a case for maintenance against his father who was 99 years old. He said, I'm unable to maintain myself. I am not in a position, I do not have any finances. My father is bound to maintain me. The father contended, I am already in my last stages of my life. I am already 99 years. How could I provide maintenance to my 77-year-old son? Then the court in this case said the age is not the criteria. What is the criteria for awarding maintenance is unable to maintain oneself, be it a aged person or a young person. The question is, it is the duty of the other side to maintain them. That's the reason in India we say it in a lighter way that always the children are parasites on their parents. Even after they are married, they depend on their parents for their maintenance, not only for their maintenance but also for their spouses and the children also. But in America, that's not the scenario. In America, the question is, once the child passes his intern, he is thrown out of the house. He looks into a part-time job, applies for an education loan, gets himself qualified, searches for a job, and maintains himself. And that is the reason. And here, as far as Christians are concerned, to some extent, what they do is, once a boy or a girl gets married, they are sent out and to live for themselves along with their families, so that there are no skirmishes or exchanges in the house. So maintenance is one thing for food, clothing, etc. When a person is not able to maintain himself or herself, the question is, the maintenance can be claimed. That is what is called Jivanamsham. Or in Hindi or Urdu, it is called Nafka. Then next one is minor. Who is a minor? Minor is also called a ward. Minor is a person who has not completed the age of 18 years. He is called a minor. Then, what is called adoption? Adoption means where you don't have children, then in that case, you take in adoption from another family and bring up that child as if it is your own child. And the question is in Hindus, there are three classes of putras or sons rather. One is called the Aurasa Putra, another is called the Datta Putra, and another is called the Dasi Putra. Aurasaputra is a child, a son who is born biologically between the husband and wife. He is called the Aurasaputra. Dattaputra is when a person doesn't have a male child, a child is adopted, a child is taken into the family by by the parents. He is called a Dattaputra. Dasiputra means a child which is born to a dasi or an exclusively kept concubine or a mistress, rather, I put it in a more decent word, uh, that child is called a dasi putra. The question of interpretation had come before the Supreme Court whether a dasi putra is entitled for rights of inheritance. But the Supreme Court in this case categorically said the illegitimate mother may not get a right, but as far as the Dasi Putra is concerned, he is entitled for inheritance. And even the Supreme Court has gone to the extreme extent of saying even an illegitimate wife also is entitled for maintenance under certain circumstances. Then, sir, there is a case law AR 1986 AP 126. The absolute obligation to maintain the child cannot be circumvented on the ground that such duty as only if the child surrenders the protection and care of the parents. It is said at any cost, it is the obligation of the parents to maintain the child, and it cannot be circumvented, it cannot be avoided on the ground that such duty ends only if the child surrenders the protection and care of the parent. Suppose it is said, I am not going to maintain the child. No parent can say that. Till the child attains the age of majority, it is the duty of the parents to maintain the child, to provide education, to provide maintenance, to provide all the other needs as far as the minor is concerned. And this cannot be avoided. This cannot be circumvented at any cost. That was the judgment rendered in AAR 1986, AP 126. The next judgment is 1987 Orissa AR 1987 Odisha 251. Maintenance does not include legal expenses. Suppose the child is driven to the court due to any reason and whatever expenditure is incurred for the litigation, as far as the expenditure is concerned, the child cannot claim expenditure and claim legal expenses from the parent against whom a maintenance case has been filed. That was decided in AR 1987 Odisha 251. This is as far as section 3 and section 4 are concerned. Then we go to the topic in the proper perception. This particular enactment, Hindu Law of Adoptions and Maintenance Act, itself clearly shows it applies only to Hindus and not to other communities. Why? Because the word that is used is Hindu. Suppose you want to know the definition of the word Hindu, you have to go to Constitution. Article 25 of the Constitution says a Hindu means a Hindu, a, a Hindu, then a Farsi, Parsi, then you have got what is called the Sikhs, Buddhists, Jains, Agarwals, and all come within the definition of the word Hindu. I think perhaps most of you know the genesis of the Khalistan movement in Punjab was based on this. They wanted the word Sikh to be removed from Article 25. They said we want to be recognized as a separate community and we don't want to be recognized as Hindus. Of course, you know that movement also was arrested. It didn't take the shape. So here, the question is Hindu law of Adoptions and Maintenance Act of 1956 applies only to Hindus and not to other communities. Then we go to section 5. An adoption is void and it shall become neither creates any right in the form of adoptive family in favor of any person what you could have had acquired except the by reason of adoption, not destroy the rights of any person in the family of his biological parents on his or her birth. Please remember, an adoptive child is something like a Maharaja or a Maharani. The question is, just because the child is given in adoption, just because the child surrenders a surname, it doesn't mean that he or she loses the right as far as the biological parents are concerned. This adoptive child gets the rights in respect of succession not only from the adoptive parents' family but also from the biological parents' family. So, the question of the adoptive child losing the rights of succession over the biological parents' property does not arise. This section 5 makes it very, very clear, saying that the adoptive child not only gets the rights of succession as far as their adoptive parents are concerned or his biological parents are concerned. His rights are not lost, not destroyed, or not wound up. That's what section 5 says. Then for this, there are judgments. AR 2014, Karnataka 104. Adoption of a boy more than 15 years is void and violative of section 10, even if it is registered. So the question is, till what age you can take a child in adoption, sir? The child should not cross the age of 15 years. Suppose you take a child beyond 15 years, that adoption, even though the deed of adoption may be registered, it has no value in the eye of law. It can be rejected and it is invalid and it is not enforceable under the law. So under the law, to take in adoption, the child should be below the age of 15 years. That's what the AR 2014 Karnataka 104 laid down. Then we go to the next ruling, locus standi to challenge adoption. AR 2016 Chhattisgarh 126. AR 2016 Chhattisgarh 126. The brother of the adoptive father, though not a party to the adoption, can challenge as if his right in ancestral property may get affected. So the adoptive father's brother also can bring an action challenging the adoption, though he is not a party to the adoption, because he apprehends that his rights in succession would be diminished if the adopted child comes into the family. So, not that I'm not saying that it will be sustained, but he can file an action challenging the adoption of the boy. That's what on locus standi, this was decided in AR 2016 Chhattisgarh 126. Then we say, suppose let us say there are agricultural lands. In agricultural lands, correction in revenue records, all rituals and followed and contain particulars of adoption and biological parents procedure in revenue records does not take away the rights of adoption and directions to correct records were issued. Here, suppose the adoptive child comes into the family and the subject matter of the property is agricultural land. Prior to the adoption, this adoptive child did not figure in the revenue records. But having come in adoption through varied process, giving of adoption, taking in adoption, accepting the adoption, competency of adoption, competency of the biological parents, competency of the adoptive parents, competency of the child to be taken in adoption. If all those things are fulfilled and all the legal formalities required for adoption is maintained and it is reduced in the form of writing, in the form of an adoption deed, and it is duly registered, the question is, if this boy's name is not found in the revenue records, ultimately, once he comes in adoption, producing the adoption deed and also proving the adoption, his name can be included in the revenue records. What are the requisites of valid adoption, sir? The biological parents giving in adoption should be competent to give in adoption. That means they must be of the age of majority, number one. Number two, they must be of sound mind. They must not be an idiot, or they must not be otherwise disqualified by any law for the time being in force. So, competency of the biological parents is absolutely necessary and essential. Second one is competency of the adoptive parents to take in adoption. The question is, as far as what applies to the biological parents also applies to the adoptive parents. They must also be competent to take in adoption. Third one is the child which is sought to be taken in adoption must also be competent to go in adoption. That means the child should not be more than 15 years of age. These are the requisites of a valid adoption. Then, case law on this is AR 1996, Supreme Court 591, where adoption takes place by the ceremony of giving and taking, it is valid. What is important? Something like a contract, sir. Why, sir? Why? Because the biological parents offer to give the child in adoption. And when does the offer become valid? Offer when it's accepted by the acceptor, that is the adoptive parents, with consent of both the husband and wife, not only of the biological parents, but also of the adoptive parents, and it is duly registered as per law, the adoption is valid. And please remember, adoption is followed only again. I'm repeating. It only applies to Hindus and not to other communities. Then next judgment is AR 2004. I'm sorry, AR 2000 Odisha 158. Here, where the adoptive mother denied adoption, the onus of proving adoption is on the plaintiff. Okay. In Hindu law, normally the husband is referred to as Ardhanarishwara. There is half Shiva and half Shakti. Shiva cannot live without Shakti, and Shakti cannot live without Shiva. Both are the same. That's the reason why the Lord Shiva is still worshipped as Ardhanarishwara. Both are equally strong, both are equally powerful, both have same powers, so on and so forth. The question is, even in marriage also, once a saptapati takes place, both the bride and the bridegroom get yoked in a wedlock. Till that time, they were a bachelor and a spinster. But by marriage, they become one. And for all practical purposes, the husband and wife are one and the same person. They take oaths across the holy fire, and across the seven steps are taken. That is what is called Saptapati, and Saptapati completes the marriage. But here, the questions as far, let us not go into that. That is as far as property rights are concerned, they are different. That is the irony of Indian law. Here it is said, when the adoptive mother denies adoption, the onus is on the adoptive son to prove adoption. How is adoption proved, sir? To say that there is giving and taking. Adoption was given by the biological parents. It was taken by the adoptive parents. Both of them had competence, and the child was also below the age of 15 years, competent to be given in adoption. Then, in that particular case, suppose let us say the adoptive wife, adoptive father and adoptive mother. The mother challenges the adoption. Then the burden of proving adoption will be on the person who has taken in adoption, and he has to prove and establish a valid adoption has taken place. Then AR 2004, Supreme Court 1257. There is no prohibition in law that the ownership in a property cannot be gifted without its possession and right of enjoyment. In this case, gift was executed in 1945 and remained in force for 25 years, during which the donee had attained majority and had not been repudiated. Held, the donor cannot cancel the gift and execute a will in respect to the same property. In this in this peculiar case, what happened was a gift was executed by the father in favor of the child, and the gift remained, and it was duly registered also. and the gift remained in force for a period of 25 years. In the meanwhile, the beneficiary of the gift, that is the son, attained age of majority. And then the father wanted to repudiate the will and cancel repudiate the gift deed because it was without possession, and wanted to take back the property, and he executed a will in respect of that property. Here the court said handing over possession or delivery of possession is not material as far as the gift deed is concerned. Once a gift deed is made and it is 25 years have lapsed and the beneficiary, that is the donee, had attained the age of majority, such a gift cannot be repudiated, cannot be rendered invalid just because of a will being executed in respect of the same property which was gifted. Then, sir, a validity of adoption were more than 15 years. AR 2017, Madras, page 37. AR 2017, Madras, page 37. The, the age of the adoptive son was 20 years, right? What does the statute say? Statute says you cannot take in adoption of a child which is more than 15 years. The age of the adoptive son was 20 years. There was no custom or usage which was proved or established saying that such a even a boy above 15 years can be taken in adoption. The courts in this case said once the custom or usage is not established or proved or set up, and it's not proved beyond a particular thing, then they said the question is a child above 15 years cannot be taken in adoption at all. So to allow this particular contingency to arise, what should happen is there must be a custom, there must be a usage which has assumed long proportions and which has been continuously enjoyed by people of a particular community, of a particular caste, of a particular subcaste, or a particular tribe, or a particular group, or a particular family. Unless that custom and usage is proved, the question of taking a boy above 15 years in adoption, and when a child is only 20 years, such an adoption is not valid. This is what was held by the Madras High Court. Then we go to the next ruling, sir. AR 2011. Please note down AR 2011 SC 644. A person having a wife cannot adopt without her consent. The court cannot presume that simply because the wife is present at the time of ceremony, it cannot be held that she gave her consent. In 2011 Supreme Court, what happened was 644. The biological parents were present, the adoptive parents also were present, and the rituals went on, the ceremonies went on, the Tattva Home, as you call it. And the wife also participated in the proceedings. And just because she is present in the ceremonies, just because she is present in the rituals, just because she is a party having attended the rituals, it cannot be said that she has given her consent. So her consent should be unequivocal, unqualified, and absolute. Unless consent as a wife is given, the question is adoption is not valid. That's what the Supreme Court has laid down in 2011 SC 644. Then we go to section 8, capacity of a female Hindu to take adoption. Sir, till now we have only discussed only a male can take adoption. Of course, the question is subject to a rider that the consent of both the couple, husband and wife, has to be taken. The husband alone cannot give in adoption. The wife also should consent. Wife also should agree. And unless wife's consent is given, the question is adoption is not valid. But now the question arises whether a female Hindu can take adoption. Here it is said, section 8 says, it is permissible for a female Hindu who is of sound mind and above 18 years to take adoption, provided she is not married or a widow or a divorcee, or after marriage as husband has renounced the world. This was as per the Act 30 of 2010 and reported in AR 2008 Supreme Court 1056. AR 2008 Supreme Court 1056. AR 2008 Supreme Court 1056. Here, a question arises. Till now, we have discussed about the males. Now we discuss about the females. Can a female Hindu take adoption or take in adoption? It says a female Hindu who is of age of majority, who has attained the age of 18 years, who is of sound mind, or who is not married, or who is a divorcee, or who is a widow, or whose husband has renounced the world, she can definitely take in adoption. There is no discrimination between a husband and wife as far as adoption is concerned. And this was laid down by the dicta of the Supreme Court in AR 2008, Supreme Court 1056. This is what all we have done in the last class, that is still section 8. We go now further. Section 9, persons capable of giving in adoption. No person except father or mother is guard or guardian. Father and mother equal rights. It cannot be done if one of them has renounced the world or ceased to be a Hindu and declared of unsound mind, where both of them renounce the world or abandon the child, or of unsound mind, where the parentage of the child is not known, the guardian may give the child in adoption. This is an unfortunate situation which arises in section 9. Section 9 says, who can give in adoption? Higher God nahi जा सकता. It is only the parents, it is only the husband, father, and mother who can give in adoption. Second condition is they must be of sound mind and they must have attained the age of majority. And third one is that if one of them has renounced the world and become a sannyasi, the question of giving in adoption doesn't arise. Or next condition is if the husband or the wife ceases to be a Hindu, converts into another religion, they are not capable of giving in adoption. And next one is if the child is abandoned or both the parents pass away, they expire, and the child is uncared for. He has no person to look after him. Or let us say both of them renounce the word and become sannyasi and sannyasins, or what they call yogins, or they become of unsound mind. They are admitted into Eragata. Then in that particular case, the child which is not taken care of, the guardian of the child, whoever be the near relative, can give the child in adoption. These are the competency of persons who are capable of giving in adoption. Then we go to abandonment. Yes, excuse me, please. Abandonment means gali వదిలేయడం, uncared for. The child is left an orphan, though he has got parents. The child is uncared for. The child is thrown on the streets. The child is given up by the parents. The child becomes an orphan. No one to take care of that child. The child is thrown on the roads. It's called abandonment. Here it is said in AR 2015, Allahabad, page 33. Mother of the child was deaf and dumb, and the information of the father, and there was no information of the father. Both the parents are living, father and both parents are living in a protection home. Mother was incapable of taking care of her child due to her disabilities. She deserted the child. This amounts to abandonment. Before guardian is therefore, guardian is granted permission for the welfare of the child, understanding of the child, and no rewards is given. Here, unfortunate scenario was the mother of the child was deaf and dumb. She was in the protection home. She gave birth to a child. Who was the father? The parentage was not known, and she was living in a protection home, and she was incapable of looking after the child. Then, because she was deaf and dumb and she was at the mercy of the protection home, she abandoned the child. She left the child to the winds. In that particular case, it was said that the guardian of the child, whoever is the near relative, can give the child in adoption and be considered as the biological parent as far as the child is concerned, because you cannot, welfare of the child is more important. You cannot allow the child to remain in the protection home along with the mother and beyond the age of 7 years. That is, a child will not be allowed to stay in the protection home for more than 7 years. The mother is not able to take care of the child. The welfare of the child is more important. The paramount consideration is the child has to be looked after properly. He cannot be kept in the protection home when he reaches above 7 years of age. That is the reason why the guardian has been given the power to give the child in adoption to any person whom he likes. Then protection can be granted. Then effect of abandonment of child by deaf or dumb father, stepfather's right to give in adoption cannot give adoption with his biological mother. AR 2016, Punjab and Haryana, Punjab and Haryana, page 140. Here it is said an adoptive, that is, it says stepfather's right to give in adoption cannot give adoption with his biological mother. So stepfather means where the mother has married again, and such a person is called a stepfather, and the mother along with him joins the stepfather. Whether the child can be given in adoption was the question raised in this particular judgment. In AR 2016, Punjab and Haryana 140, they said a stepfather cannot give in adoption. He is not capable of giving adoption. Though he joins his wife and gives in adoption, that adoption is not valid at all, and a stepfather is incapable of giving in a child in adoption. Then we pass on to section 10. Persons who can be adopted, he or she is a Hindu, not already adopted, then he or she already married, unless there is a custom and not completed the age of 15 years. Here it says persons who can be adopted. First, he or she is a Hindu. So please remember this enactment itself applies only to Hindus. So the adopted child should be a Hindu, number one, by caste. Number two is the child should not have been already adopted by other parents. Third one is he or she is suppose that he or she is already married. Then the question is, unless there is a custom that even a married son or a married daughter can be given in adoption, unless that custom is proved and established, such a child cannot be given in adoption. And fourth one is he has not completed the age of 15 years. So these are the persons who can be given in adoption. First and foremost is the person to be given in adoption should be of the age of below the age of 15 years. Number two, he or she must be a Hindu. Third one is he or she should not have been already married, unless there's a custom to show even birth children could be given in adoption. And then this custom should be proved, established, and set up beyond any shadow of doubt. There is no implied prohibition for adoption amongst relatives by blood since 1956, where plaintiff was the son of the half sister of his adoptive father, and registered deed of adoption was also produced and recorded, leading to presumption of valid adoption. That is AR 2016, Punjab and Haryana 132. This is a division bench judgment. Half sister. What do you mean by half sister? Half sister means that is born of a different father. Born of a different father. Then the question is, there where the question that arises, there is no implied prohibition for adoption amongst relatives of blood since 1956, where plaintiff's son was the son of half sister of his adoptive father, and registered deed of adoption was also produced on record, leading to presumption of that. So what all is important is, irrespective of all these things, the biological parent should have capacity, the adoptive parent should have capacity, the adoptive child which is given in adoption should be below the age of 15 years, and he or she should be below the age of 15 years. And next one is he or she should be a Hindu, and it should not have been already adopted by someone else. And fourth one is the custom or usage to give in such adoption should be recognized and should be established before the court. Then this judgment of 2016, Punjab and Haryana 132 says, if the son of a half sister is given in adoption to our half brother, then in that case, such adoption is valid. Suppose give and take is there, and capacity, competency, everything is established, then adoption will not fail. The proof of adoption is AR 2017 Delhi page 15 marriage card and other uh, documents. That is proof of proof of that is why proof of AR 2017 Allahabad 15 marriage card and other documents, proof of adoption in some Gotra. Here, you know, this particular ritual is followed only among Brahmins. Suppose Sagotra is there, people, you can take a child from the same Gotra in adoption. There is no bar for it. Then, what is the proof, sir, of our proof of adoption, sir? The marriage card, then the other documents which support the legal marriage between the couple who are giving in adoption, and this was decided in AR 2017, Delhi page 15. Then proof of adoption in same Gotra. Then AR 2016, Guwahati 52, non-completion of 15 years, severance of religious ties with biological parents. Then there was no material on record to prove actual physical act of handing over and taking over by way of any ceremony. Adoptive mother denied alleged adoption. Here it is said giving and taking is absolutely a must. Giving by the biological parents and taking by the adoptive parents, natural biological parents, and taking by the uh, adoptive parents. And there must be a ceremony evidencing the adoption ceremony. And then there must be a physical act of handing over the child and taking delivery of the child. And then the claimant cannot. The claimant continued the identity himself as son of his biological father even after adoption. The claimant failed to prove any valid adoption in accordance with law, and there was no severance of ties with his biological parents. So, for adoption to be valid, the adoptive son should sever all his ties with his biological parents, assume the surname of his adoptive parents, and then also describe himself as the son of the adoptive parents. But if he still continues to use the name of his natural parents or the biological parents, and in all records his name is shown as son of the biological parents, such an adoption is not valid under the law. Then we go to section 11, sir. Section 11, what are the valid conditions for adoption? Here, where the adoption deed is not registered but a but notarized. Such document is not admissible in evidence. This is AAR 2000 Allahabad 166. So, suppose giving and taking is there, handing over the child is there, and taking the child in adoption is there, rituals are there, ceremonies are celebrated, but still the question is the document adoption deed is only a notarized document. Please remember, a notarized adoption deed is not admissible in evidence. An adoption deed has to be compulsorily registered under Section 17 of the Registration Act. Unless the adoption deed is duly registered under the provisions of the Registration Act, a notarized adoption deed is invalid and not maintainable in court. That was what was held in AR 2000 Allahabad 166. Then, sir, AR 2001 Supreme Court 2725. AR 2001 Supreme Court 2725, where from the evidence of record it is found that the appellant had miserably failed to prove that she was validly given in adoption by her father and taken in adoption uh, by the adoptive parents, Ganguly. Both the courts were right in rejecting the plea of adoption. AR 2001 Supreme Court 2725 says absolutely you cannot give a go by for giving in adoption by the biological parents, taking in adoption by the adoptive parents, and also the handing over the child to the adoptive parents by the biological parents, and all the requisites have to be followed. There was no proof established to show that there was give and take and ceremonies were performed. Then, in that case, the adoption failed and adoption is not enforceable. And this was held in AR 2001 Supreme Court 2725. Then we go to registered deed cannot be challenged in a case. This was decided in AR 2016 Calcutta 141. In both certificate of adoptive child, the the authorities could not deny the change of age on the ground that the authorities could not deny the deny the charge age on the ground that the adoptive father had natural son at the time of adoption, as registered deed is presumed to be his son was adopted by giving good education, etc. Genuine, as said here, the adoptive parent already had a child, had a male child. They said here the Calcutta court said once he has got a natural child, he is prevented from taking another child in adoption, and the adoption is invalid. This was decided in AR 2016, Calcutta 141. So this is as far as Section 11 is concerned. Now we go to Section 12, effects of adoption. That is 2000. The citation is 2000 bracket 1 ALT 218, which deciding whether minor is an indigent person or not, the financial condition of the guardian or other relative is not relevant. An adopted child is deemed to be the child of his or her adoptive father for all purposes from the date of adoption, and from such date all the ties of the child shall be deemed to be severed and created by the deed of adoption. Here, while dealing whether minor is an indigent person or not, the financial condition of the guardian or other relative is not relevant. An adoptive child is deemed to be the child of his or her adoptive father for all purposes from the date of adoption, and from such date all the ties of the child shall be severed from the severed and created by the deed of adoption. So once adoption takes place, the suppose it is filed as a pauper, then the financial condition of the guardian or the adoptive parents will be taken into consideration to decide whether pauperism should be allowed or not. Then there's a proviso also, sir, which says it is plain and clear that the adopted child shall be deemed to be the child of his or her adoptive father or mother for all purposes with effect from the date of adoption, and he or she cannot be divested of any estate vested in her before adoption. That is what was decided in 2003. Please note down, sir. 2003 bracket 1 4 SCC 2003 1 SCC 71 or 2003 Supreme Court 1735. Here, once a child, be a male or a female below the age of 15 years, is taken in adoption, the question is for all practical purposes, he or she will be described as a child of the adoptive parents, and she cannot be and whatever rights she had in her biological parents' property, she gets the rights in that biological parents' property also, as well as the adoptive parents' property also. That was 2003 Supreme Court 1735. Then next judgment is AR 2014 Hyderabad, page 12. An adopted child would not lose rights in co-personal property of our natural family. So, as far as ancestral property, co-personal property, or the biological parents are concerned, the child which goes in adoption, be it a male or a female, does not lose her rights. She is definitely entitled for a share in the co-personal property of her biological parents. Then, sir, we go to here if the property is vested in the widow and three daughters of the deceased, inheritance would not be disturbed by virtue of subsequent adoption. Suppose, let us say, the property is this is AR 2016 Supreme Court AR 2016 Supreme Court, AR 2016 Supreme Court 5253. If the property is vested in the widow and three daughters of the deceased, inheritance would not be disturbed by virtue of subsequent adoption. Suppose a male child is taken in adoption and the person concerned, the property is vested with the widow. She has lost her husband and her three daughters. Simply because a child has been taken in adoption doesn't mean that the child takes the entire property. The question of inheritance remains as it is. 3 plus 1, that is 5 shares will be made out. That was what was decided in AR 2016 Supreme Court 5253. Then right of adoptive parents to dispose of their properties by transfer or will. So as far as the adoptive parents are concerned, they can at any time dispose of the property, they can transfer the property, they can will away the property. There is no embargo not to do it. Then the determination of adoptive mother in certain cases where the adoption has been made with the consent of more than one, this senior most suppose let us say a Hindu has more than two wives, more than one wife rather, I put it that way. He has got, of course not, I don't use the word begum. It is wife number 1, wife number 2, wife number 3. Like what is called Kausalya, Kaikeyi and Sumitra. Then in that case, when the question of adoption has to be given, whose consent will prevail? The senior most among them, of course I should not use the word, the senior begum, so consent is important along with the father. So the juniors do not play any part in that. Then, where a widower adopts a child, any wife whom he subsequently marries is his stepmother. Where a widow or an unmarried woman adopts a child, any husband she marries subsequently is a stepfather. Then who is a stepmother, sir? Suppose, let us say, where the adoption has been made with the consent of mother, that's where. Then where a widower adopts a child, any wife, suppose let us say a widower, a person who has lost his wife, gets remarried, right? Then where a widower adopts a child, any wife whom he subsequently acquires marries is the stepmother of the child. Then where a widow or an unmarried woman adopts a child, any husband she marries is called the stepfather. So here the first one is where a widower, a person who has lost his wife, takes a child in adoption and subsequently marries, he is called the adoptive father, and the mother, the wife whom he marries is called the stepmother. And where a widow or an unmarried woman takes in adoption, takes a child in adoption but marries subsequently, she is a stepmother. Then next aspect is valid adoption not to be cancelled by the adoptive father or mother or any person, nor can the adopted child renounce the status and return. Return to her natural parents. Here it is said, where an adoptive father or mother or any person, in either case, the adoptive child renounced by the adoptive father, that valid adoption not to be cancelled. Suppose an adoption has taken place properly, all the rituals have been followed properly, giving and taking is also proved and established. The child which is taken in adoption cannot renounce her adoptive status and go back to the biological parents, and this is what is prohibited under the law. Neither the adoption can be cancelled, nor the adoptive child can go back to our biological parents and leave this adoptive parents' family. The presumption that the child is taken in adoption, section 15 and 16, that is section 15 and 16 says that there is always a presumption that there is a giving and taking, handing over the child, taking custody of the child, valid rituals as per the customs being followed, and all the rituals and all the formalities have been completed, then there's a presumption that a valid adoption has taken place. That is what Section 15 and 16 lays down. Then Section 17, prohibition of certain payments. Neither the natural parents or adoptive parents can receive payments towards adoption. That is what is called child trafficking. Here, the biological parents who give in adoption, the adoptive parents who take in adoption, there should not be any money exchange or any reward paid for the transaction. It should not be made a business. That's what there's a bar of prohibition under Section 17. Neither the adoptive parents nor the biological parents can receive any payment towards the adoption. That is what is called AR. That is a judgment reported in AR 2003 Supreme Court, AR 2003 Supreme Court 3314, AR 2003 Supreme Court 3314. This section is enacted to prevent trafficking of children. If suppose it is why this section is provided, sir, it should not be a regular business of giving a child in adoption, taking a child in adoption, passing of money by the biological parents, or passing of money by the adoptive parents, or any reward being given for that. And this will encourage only what is called trafficking in children. This is what is prohibited. And if this comes to light, then imprisonment of 6 months and 1,000 rupees fine is imposed for this particular offense. This is as far as the subject on adoption is concerned. So, next part of it, from section 3 to section 17 deals with adoptions. Section 18 to end, that is section 28, deals with what is called maintenance of wife. Section 18 of the HAMA, or what is called Hindu Law of Adoptions and Maintenance Act is concerned, says guilty of desertion or abandonment or cruelty, suffering from leprosy, or if he has any wife living, concubine, he cannot be a Hindu by conversion, justified cause. Here it is said, as far as maintenance is concerned, if a husband who deserts his wife, who is guilty of desertion and abandonment, leaves the wife to the winds, does not take care of his wife, and the wife has no means to support herself, she does not have the wherewithal or roti, kapada, or makan, or the husband has got means but is not maintaining the wife, he has abandoned the wife, left her to the winds, and making her beg on the streets, the wife is entitled to claim maintenance from her husband. Or the husband is guilty of what is called cruelty. He has treated the wife harshly, he is guilty of physical and mental violence, or he has treated her not as a wife but as a servant maid, or he has indulged in certain acts which amounts to cruelty under the law. Third one is the husband is suffering from leprosy, which is incurable, or and the wife comes to know that he has got another wife living and he has suppressed this fact and got married to her, or he has got, let us say, he has got a concubine or what is called a mistress. Of course, I don't want to use the word in Telugu. Sana vetkunnadu anamata. Sana unda. Then the question is, he cannot be Hindu by, then he ceases to be Hindu by conversion into another community. Then for all justifying causes, a claim for maintenance can be maintained under section 18. Then, or she has got reasons to live separately, where where it is harmful and dangerous for her to live with her husband, or the husband has tortured her to such an extent she has lost her complete peace of mind. She has no sufficient means to maintain herself, to keep her body and soul together. The husband has got converted into another religion. Then the husband has got a concubine or a mistress, or then the husband has got a wife living even before marriage, or is guilty of cruelty, or he has deserted and abandoned the wife. Then in that case, a wife who does not have independent means of livelihood to maintain herself can maintain an action for maintenance against her husband. Then AR 2005 Supreme Court 986, right of residence is part of maintenance. Of course, now we have got another enactment called the DVC, or the Domestic Violence Act. In the Domestic Violence Act, provision should also be made for the residence of the wife. Here, Section 18 also recognizes that right, and this was upheld in what is called AR 2005, Supreme Court 986. They say right of residence also includes, is also part of maintenance. The husband has to provide residential accommodation to the wife to live. Then Section 18 and 20, Supreme Court will not entertain an appeal where it is directed against interim maintenance. AR 2004, Supreme Court 3453. Please note down this, please. 18, Section 18 and 20 is AR 2004, Supreme Court 3453. This is regarding Section 18 and 20. The Supreme Court will not entertain an appeal where it is directed against interim maintenance. So against an interim maintenance, no appeal lies. The question is, if you have to pay whether you like it or not. So question is, it says no appeal is maintainable against an order passed for interim maintenance. That is AR 2004, Supreme Court 3453. Then Section 19 deals with what is called right of widowed daughter-in-law. It is a duty of the father-in-law to provide. This is decided in AR 2016 Chhattisgarh 135 Division Bench. It is a duty of the father-in-law to provide maintenance uh, and depending on his income. So once the lady becomes a widow, she is dependent upon the family. She loses her husband, and she is dependent completely on the family of her husband. The father-in-law of the girl is bound to maintain their daughter-in-law subject to his means, and the daughter-in-law has got a right of claiming maintenance from her father-in-law. I think with this section we shall stop. That is, we have come up to section 19 of the HAMA, or what is called the Hindu Adoptions and Maintenance Act. The rest of it we'll discuss in the next lecture. Thank you.